Professor Blackman will be giving a very interesting talk, so please give him a warm welcome.
I hope it's interesting.
Please give him a warm welcome for being here.
Thank you.
So just a brief introduction before we get started. Professor Blackman is an associate professor at the Houston College of Law. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of the critically acclaimed book, Unprecedented, The Constitutional Challenge to Obamacare, an additional book, Unraveled, Obamacare, Religious Liberty, and Executive Power.
In bookstores now if you want to buy a copy.
Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. And he's also testified before the House Judiciary Committee on the constitutionality of executive action on immigration. He clerked for the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit, and also for the Honorable Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. And last but not least, he's a graduate of the recently renamed George Mason University School of Law.
Thank you.
I'd also like to introduce very quickly our very own Professor Jim Speta, who's the class of 1940 Research Professor of Law and Senior Associate Dean for Academic Affairs and International Initiatives here. He's also the Director of Executive LLM Programs, and his research interests include telecom and internet policy, antitrust, administrative law, and market organization. He also teaches in the Joint Program in Law and Business, which is operated by the Law School and Kellogg. He's a 1991 graduate of Michigan Law School, faculty here following a one-year visit. He's previously clerked for the DC Circuit, and he also practiced appellate, telecom, and antitrust law with Sidley and Austin, which a lot of us know about here. So again, please give a warm welcome to Professor Blackman and Professor Speta. Thank you very much.
Thank you so much. It's a pleasure to be back at Northwestern. Your school got more money for naming rights than my alma mater, so I guess you guys did pretty well. Okay, there it is. I thank you all. I'm here today to talk about a new book, Unraveled, Obamacare, Religious Liberty, and Executive Power, but with a special focus on executive power, the third part of the title. And the subtitle for today's lecture is Regulation by Blog Post. And I would like to discuss the various ways in which the ACA has been changed, modified, delayed, and suspended through executive action in ways that are inconsistent with both the text and history of this not even 6-year-old statute. So to understand, we need to start with Congress and the way in which the ACA was passed. Think all the way back to 2008, when most of you were still in diapers, I suppose, during the last major presidential election. At the time, President Obama won a resounding victory. In the Senate, Democrats had 60 votes. They had a 30-vote lead in the House of Representatives. Republicans had no interest in supporting the healthcare reform. They simply said, we're not interested. So a very important decision was made by the president and Democrats. The decision was made to pass this on a straight party line vote without a single Republican vote. Now, there are pros and cons to this decision, which we'll talk throughout, but this was a very significant decision that was made. But an important consequence of this decision is Republicans had no investment in the law, and they were content to sabotage it, vote against to repeal it, and do nothing to perhaps ameliorate it. So whether or not this decision was the right one, the consequence of the decision was to put the ACA on this footing where the legislative process was largely unable to touch it. And that's what I'd like to talk about today. So back in 2009, Senator Reid said we will pass this Affordable Care Act in the Senate. The version that was passed in the Senate was nearly 3,000 pages. It was first released in its final form in December 2009. No one read it. In fact, the chairman of the Finance Committee, Max Baucus, said, I don't read bills. I pay people to do that for me. And I suppose that's how government works. But an important point to recognize is that the version passed in the Senate in 2009 was never meant to be the final version of the bill. It was only a draft. The idea was, let's pass this Senate bill, send it to the House. The House will pass their version of the bill, send it back. And there'll be this reconciliation process to perhaps work out all the kinks. That process, my friends, never happened. Why? Because the passing of Senator Ted Kennedy. He had passed away in the summer of 2009, and with that, the Democrats' 60th vote was in flux. So at first, the Massachusetts governor, Deval Patrick, appointed a placeholder, a Democrat, to fill the seat. But then in January of 2009, Scott Brown won a special election in Massachusetts. He was a Republican voted into office to replace Ted Kennedy. And as a consequence, the Democrats lost their 60th vote in the Senate. The bill went to the House. But critically, Speaker Pelosi was unable to make any significant changes to the bill. Why? If any major changes were made to the bill, it would have to go back to the Senate. And at that point, Republicans could kill it with a filibuster. So the bill we have today, right, this Obamacare, Federal Care Act, whatever you want to call it, was a draft. Something that transformed nearly 15% of the U.S. economy was never meant to be final, but was only rammed through that problem. Although I won't talk about all the cases, the decision of King against Burwell. This was that the ACA said you only get subsidies on exchange established by the state. I'm going to argue that today. But you can be pretty damn sure that for this one through the reconciliation process, that language would probably been changed. It wasn't changed. We were stuck with it. Supreme Court bailed them out. Okay. In any event, the ACA passed on a straight party line vote. Take a look at this. Make a mental note. 34 Democrats voted against it. I'm going to take a timeout. Can everyone please take their sandwich out of the wrappers right now? Stop making that noise. Take it out right now. Just take it out of the wrapper. 1, 2, 3, go. Everyone? Okay, good. No more crinkling. Thank you. So, wise guy. The bill passed on a straight party line vote without a single Republican senator supporting it, or a single Republican member of the House supporting it. This was momentous because as the bill proceeded, there was not a single effort of buy-in by Republicans to do anything positive for the bill. They had no investment in it. If you want during the Q&A, we can talk about that, but that is the harsh political reality. So this went to the president's desk. He signed it. If you see here, he has his 23 pens, which he uses as commemorative. Like he signs a different part of his signature with each pen, and he hands it out as tokens of gratitude. This was March 23rd, 2010. Do you think you could have ever predicted what lied ahead? Absolutely not, because within minutes, 7 minutes to be exact, within 7 minutes of the signing, lawsuits were filed across the country challenging the constitutionality of the Affordable Care Act's individual mandate. The ACA's mandate, in short, requires people to purchase health insurance. The failure to do so results in the payment of a fine. If you'd like to learn more about this, read my first book, Unprecedented, the Constitutional Challenge to Obamacare. Maybe I can talk about that another time. But in a long story short, and a decision that breaks my heart every time I read it, the Supreme Court said, guess what? There is no mandate. In fact, the ACA is merely a tax on not having insurance. Therefore, it's constitutional. Chief Justice Roberts cast a deciding vote to uphold the law. Constitution, as it were. That's where my first book left off. And we had Governor Romney running for presidency saying, I am going to repeal and replace Obamacare. This was always illusory. Why? Because he basically invented Obamacare. In the state of Massachusetts, he instituted a healthcare plan that imposed an individual mandate. So he is just as much a supporter of Obamacare, and I don't think he ever took it seriously. During the debates, President Obama called Mitt Romney the godfather of Obamacare, and indeed he was correct about that. As we all know, Romney lost in the election. President Obama was inaugurated. Actually, fun fact, President Obama has taken the oath of office 4 times. 4 times, right? So the first time in 2009, the Chief Justice flubbed the oath. Remember this? So they did it again just for safety, right? Next time in 2012 and 2013, the inauguration day, January 20th, fell on a Sunday. So they actually did the real inauguration January 20th in the White House, and then the big one in the Capitol lawn the next day. So he's had the oath 4 times, tied with Roosevelt for the most times actually taking it. Fortunately, only 2 terms yielded from those 4 oaths. And they could take another 4 years. But in any event, the Chief Justice said, you're welcome, or something to that effect. And this brings me to the second book, which was published by Cambridge 2 weeks ago, called Unraveled. The president has had a very tumultuous time in office. Increase in partisanship, Congress simply has not agreed with his agenda. I have a piece coming out in the Harvard Law Review this November called Gridlock. If you want to learn more about gridlock, read that article. But the lesson that's important to take away from today is how has the president responded to that gridlock? He's been very clear about using executive power as a way to break apart that intransigence. He's boasted that I don't need Congress, I have a pen and I have a phone. He said in the context of immigration that I take executive action when we have a serious problem and Congress chooses to do. And we've seen this time and time again with respect to immigration, with respect to war powers. You can name examples. We've seen this over and over again. I'd like today to discuss 3 aspects of the Affordable Care Act that follow the sort of pen and phone methodology. The Obamacare individual mandate, the Obamacare employer mandate, and the contraceptive mandate. Now, this is not about religious liberty. This is about executive power. So first, as I discussed, the ACA has a mandate that says you are required to have health insurance or else you pay a penalty, or if you're John Roberts, you pay a tax. But part of the mandate that people don't always appreciate is what that means. It's not just you buy any health insurance. You buy insurance that covers what's called minimum essential coverage. That means it meets a certain baseline threshold of coverage that the government deems appropriate. Insurance doesn't meet that threshold, or if your old plan didn't meet that level, guess what? Your policy is no longer valid, and you now have to purchase a policy. I'm sorry, you now have to pay the mandate. Okay. Why is this problematic? Throughout the selling of the ACA, the president promised on at least 36 occasions, if you like your plan, you can keep your plan. Why was this promise made? To avoid the pitfalls of Hillarycare. Now, most of you are too young to remember this, but in the early 1990s, Secretary Clinton, in a different lifetime, tried to impose a universal healthcare system on the United States through what was dubbed Hillarycare. Okay? One of the defining reasons why Hillarycare failed is that it would have made people lose the doctors they like. There were these commercials, which you can find on YouTube, called the Harry and Louise commercials. We had this ma and pa sitting at this table saying, you know, I don't want this Hillarycare. I'm going to lose a doctor I like. Indeed, they would have. Hillarycare would have made many policies void. So the president said, we will not repeat this mistake, and we'll make this promise over and over and over again. If you like your plan, you can keep your plan. The problem with this promise, my friends, is that it was utterly impossible to keep. Why? The entire basis of the ACA was moving people off these sort of cheap plans with very limits and moving us on to these more robust Obamacare plans. This was not a mystery. If you ask anyone, maybe Jonathan Gruber, about this, they would have told you, you can't keep your plans. Yet the president kept promising this over and over and over again because it was politically popular. It was a good message, right? We can help all these poor people, these sick people, but they'll do nothing to your plan. False. It was utterly impossible to keep this promise. And to the point, you want to go through the Federal Register? Regulation after regulation were issued saying, we expect this many millions of people to lose their plans, right? This is all in their Federal Register. And they kept telling the same statement over and over again. This did not become known, by and large, until the fall of 2013. This is when the Obamacare exchange opened up, the website crashed, the filibuster happened, Ted Cruz, all that good stuff. But amidst that entire mess, millions of Americans received letters like this. Oh, Illinois, perfect. I'm in the right state. That said, because of the new healthcare law, your plan will no longer be available. Your plan will not be renewed. The exact number of people who got these letters is not exactly known. I've seen estimates as low as 2 million, as high as 4 million. Let's call it 3. But a significant number of people received these sorts of letters saying, your policy, the one you like, is no longer void. These cancellations were a political firestorm because they directly conflicted with the president's promise that you can keep the plans that you like. Indeed, PolitiFact and others called the president's plan the lie of the year, which is funny because PolitiFact previously said the statement was true. Research and investigation, they realized, well, it wasn't quite true. So what happened next, though, is fascinating. Bipartisan, right? Members of Congress said, okay, this is not fair. People relied on this promise they can keep their plans. It's not fair that we're taking it away from them. So bills were proposed in both the House and the Senate, bipartisan, that said, you can grandfather your old plan for another year. You can keep the plan you like. In fact, one of the bills was called, if you like your plan, you can keep your plan bill, right? There's a problem, though, right, if you're the president. even though there was bipartisan support to pass this one provision, and the bill itself, I think, was like, 4 or 5 lines long. It was a very short bill. Once you open up Obamacare, you open up Obamacare for other changes. Hence, executive action. In a stunning move, the president announces a fix, an administrative fix, that will allow people to keep their plans. The timing of this is worth focusing on, right? Same day, right? This bill passed the House. On the same day the bill would have been brought up for a vote in the Senate, the president announced executive action. The executive action mooted the democratic process. In fact, this is not a situation where the Republicans said, we're not going to help at all. They were trying to do it. What the president did through executive fiat, exactly what Congress would have done. Exactly what Congress would have done. And he obviated senators from taking a very difficult vote because he knew they had to vote for it. If you're Mary Landrieu in Louisiana, right, you have to vote for this. If you're Manchin in West Virginia, you have to vote for this. So the president took it away through a series of actions called the administrative fix, grandfathering them in. Okay? So what did this actually do? Twofold. First, it told states and local insurance companies, if you want to keep selling these void policies, we will look the other way. We will not, the federal government will not enforce the requirement to say plans must meet this certain threshold. We simply will not enforce that mandate. They told states, even if you want to enforce it, we won't make you, right? We're simply going to look the other way. What else did the law do? I keep on law, it's not a law. What did the executive action do? It redefined hardship. So the law has a hardship exemption, right? That if there's some unspecified hardship, the Secretary of HHS can exempt you from the mandate. They said, if you can't afford a new policy because Obamacare made it too expensive, we will give you a hardship exemption. Now, that might sound reasonable until you actually look at the statute. And the statute has a very specific income threshold to qualify for an exemption. You have to be pretty darn poor. So they created this entire new exemption, exempted probably millions of people. Okay. There was a consequence to this also, my friends, right? The consequence is millions of people were exempted from the mandate. Do you want to know why the enrollments are so low? A lot of people simply haven't had to buy policies that meet these thresholds. In the process of salvaging the law, it was actually sabotaging it, and not by Republicans. The president has sabotaged his own law by waiving the individual mandate. As well, special enrollment periods. With Obamacare, you were only supposed to be able to sign up at certain times throughout the year. If you call HHS, give them whatever excuse, no proof, they'll let you sign up late. The insurance companies have found that these people use a lot more health care and are a lot more expensive to cover. So the reasons why premiums are going up and networks are shrinking is in large measure due to this executive action, which, by the way, winds down by the end of this year. So whoever's in office in 2017 will have a nice problem to deal with. Okay? Is this legal? No. No. The statute says the secretary shall enforce these regulations, right? The president said, nah, we're just not going to do it. We're going to look the other way. Do you want to sell these void policies? We'll ignore it. Why? Because healthcare. Statute defines hardship, and they say if you can't afford it, it's this and that. No, this is legal. Does anyone stand to challenge it? No. And that's the rub of these actions. No one is injured when the government fails to enforce the law. Indeed, people are helped. People are helped. That now someone who would have had a canceled policy can keep it. So there's no Article 3 injury. Indeed, the state of West Virginia brought a claim. Didn't work. So this is my Youngstown image of being at the lowest ebb, if you couldn't tell what the metaphor was. But these are actions where Congress said, we want to do this. The president said, no, 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 you're not going to do it. I am going to do it. The second mandate I want to talk about is the Obamacare employer mandate. This mandate basically says if you have 50 or more employees, you are required to cover their health insurance. And if you don't, you have to pay a penalty. Unsurprisingly, small businesses oppose this because it would have made their costs higher. They may have had to lay off more workers, maybe drop people down to part-time, because if you're below a 30-hour threshold, you're considered part-time. In 2013, businesses came to the president and said, you know what? That's a really nice mandate, but we can't do it. Right? We can't do it. So in July of 2013, the president announced that he would delay the employer mandate by 1 year. Okay. What was the reason why he delayed it initially? He said, well, the IRS isn't ready. They haven't gotten all their forms ready. The system isn't built yet. Color me skeptical. If you think of the website and the exchanges, those launched when they were utterly unprepared. So this wasn't the real reason. How do we know this? Because several months later, the president delayed it again for about another year and a half. This wasn't an implementation startup delay. This was because they didn't want people to actually be subject to it. But it wasn't simply just delayed, it was modified. The ACA is very clear. If you have more than 50 employees, you're subject to this mandate. But under this modified regime, if you have between 50 and 100 employees, you get one set of treatment. If you have more than 100 employees, you get this other set of treatment, right? They made all these changes and modifications to the employer mandate that are nowhere to be found in the statute. And again, does anyone have standing to challenge it? No. Businesses love this. They're not subject to this at all. Indeed, the House of Representatives actually tried to bring suit to challenge the employer mandate. That claim didn't go very far because, again, it ends after next year, so it's not a particularly effective lawsuit. But also, there was no standing. So the employer mandate, to this day in 2016, as we stand here today, still has not gone into effect. Again, this is illegal. You can't simply delay start dates and modify statutes willy-nilly because healthcare, right? Healthcare is not a reason to ignore the rule of law. Same as before, there were actually bills in Congress that would have delayed the employer mandate. But the president, again, didn't want to do that because it could risk repealing other aspects of the ACA, so he went down the executive action route. Okay, I'm going to conclude with a discussion of the contraceptive mandate. I don't want to talk about RFRA, I promise. We will not be talking about religious liberty. I want to talk about executive power. So during the origin of the contraceptive mandate, I'm sorry, let me go back. In 2009, 2010, there was a very big debate in the House over funding of abortion. The reason why this debate was salient was that Bart Stupak was a pro-life Democrat. He had these pro-life caucus, and they were very adamant that the ACA should not have any funding for abortion. Now, the law itself didn't actually change the long-standing prohibition, what's called the Hyde Amendment from your former congressman, right? That prohibits funding for abortion. In any event, President Obama signed this executive order that was worthless, said we are not changing the long-standing long-standing prohibition against abortion funding. So they were all happy. But the real movement was something that largely escaped attention. In the Senate, Senator Mikulski of Maryland passed what's called the Women's Health Amendment. Okay, this amendment says, and I put the text up here very clearly, with respect to women, insurers must provide, quote, preventive care. That's all the statute says. That's the entire provision. This may blow your minds, my friends. The ACA does not have a contraceptive mandate. What? The Affordable Care Act does not have a contraceptive mandate. All it has is a preventive care mandate. Congress passed a statute, and the word preventive care, as you know, is an ambiguous term. And under the doctrine of Chevron, the agencies decided, well, preventive care means the full range of birth control, right? It covers all forms of birth control, the entire range, including morning after pill, morning after pill, a Plan B, whatever else you want to call it, right? Full range of FDA-approved contraceptives. But a consequence of that decision, all employers are required to cover these products. There was not a single second of debate anywhere in the Senate about how religious employers should be accommodated. In contrast with the individual mandate, there was a debate. If you have a certain faith-based objection, you're actually exempt from the individual mandate's penalty. For example, if you're Amish or some other religious faiths, you're actually exempt. But there was no discussion. This omission is glaring, my friends, because the contraceptive mandate applies to all employers, all of them, even houses of worship and religious charities. Okay. Now you may say, well, wait a minute, Josh. Isn't it unconstitutional to make houses of worship pay for contraceptives? Is it under Employment Division v. Smith? I don't know. Law of general applicability? Sounds okay. Compliment can be opining later, but I think that may be okay. Indeed, the California Supreme Court has upheld similar laws that require all hosts of religious employers. So what the Obama administration did was a series of rulemaking and said, okay, first off, if you're a church, we'll exempt you. But if you're a religious charity like the Little Sisters of the Poor, you're not exempted. Okay, that didn't go over too well, right? Making nuns pay for the morning after pill, not the most popular thing to do. So he said to the nuns, okay, guys, we're not going to make you pay for these pills, but the insurance company will cover it and we'll work through your insurance plan, right? We will use your insurance plan as a conduit to provide these products. Unsurprisingly, they still objected. For-profit employers such as a Hobby Lobby Corporation also objected. But the point I want to talk about here is one of administrative law, I promise, not religious liberty. The reason why the government said, if you're a church, you're exempt, but if you're the Little Sisters of the Poor, I'll give you a visual, right? So if you're a church, you're exempt, but if you're a bus full of nuns, you're not exempt, right? Why? The government said, we think that churches are more likely to employ people of the same faith. And because HHS said we think that churches are more likely to employ people of the same faith, we will give these people the exemption, and we're going to give the nuns a sort of accommodation where we use our insurance plan. Okay? This is administratively flawed. Agencies cannot make profound decisions outside their areas of expertise. HHS, Treasury, and one other, drawing blank the agency, doesn't really matter which one, but HHS and Treasury lack the authority to decide which employers can and cannot hire people of their own faith. Indeed, under Title VII, if the nuns so chose, they could only hire Roman Catholics to work in their ministry. But when agencies make these sorts of decisions that which groups have more religiosity than others, they're acting ultra vires. So as I argued in a brief I submitted to the Supreme Court in the Little Sisters case, and also have a piece in the Harvard Law Review coming out next month, the entire contraceptive mandate is flawed. Not because of RFRA. There's some good RFRA issues too, but it's all ultra vires. They can't pick and choose which religious groups get these exemptions. It's entirely beyond their ken. This is a decision Congress should have made. And the fact that Congress was silent about this and said nothing suggests that the agencies were not delegated this source of authority. Okay. I'm going to wrap up here, and in terms of my esteemed colleague, we'll do some Q&A afterwards. But it's very important to stress, and I make this point whenever I speak, that expanding access to healthcare is an important good, right? It's an important, worthwhile task. And it's unfortunate that because of the political climate we have, it's become such a football, I mean by football, sort of political partisan issue that every dit and dot becomes this new fight. Lose sight that we have administrative law, we have a rule of law, we have a constitution, and you can't simply look the other way because it'll help some people in the short term get health insurance. And indeed, many of the changes made actually sabotaged the law and made it harder for the risk pools to get diverse, made it harder for people to sign up, and actually frustrated the growth of the Affordable Care Act. Thank you all so much for your attention. I look forward to my professor comments, Professor Speta, and your comments after. Thank you. Everyone wrinkles their paper now, right? Look at that. Wow, see, they actually listened to me. Yeah, I did a talk at Chicago, about a year or two ago, and they had these like wrap sandwiches, and I was like, everyone, take sandwich out now. And it actually worked pretty well.
So I want to stay focused for my remarks on the question of executive authority. And by saying I want to stay focused on that, I want to make two observations going in. The first of which is, whatever you think about the Obamacare and the Affordable Care Act as a statute, it was, of course, duly passed. And I will say that there is a fundamentally different story to be told about why it was passed with no Republican votes, right? A story that has to do with the state of the political discussion and an offered bipartisan compromise that was then withdrawn, right? But that really doesn't matter for the purposes of the fundamental question that I'm going to get to in a minute. The second question, the second thing I want to say about focus is the question of executive authority, as we understand it in administrative law, has nothing to do with whether the executive authority is being exercised in a wise way or in an unwise way. Now, to be sure, provisions of the Administrative Procedures Act, which are fundamentally important to respecting the rule of law in the administrative state that we have, do make questions of whether the executive action is wise or unwise, subject to a form of judicial review. Usually a light form of judicial review called the arbitrary and capricious standard, but not no judicial review. Although Professor Blackman's of course right that there have been a number of cases which have sought judicial review that under current doctrines of standing, conservative doctrines of standing that say fight between the branches as to ultimate authority. It's not the court's job to play referee between the Congress and the president. We're going to stay out of it. We are not going to decide fundamental questions. Now, you may disagree with that standing doctrine. In fact, I disagree with a lot of standing doctrine that denies access to the courts. But that's the standing doctrine as it stands now, and it is based on a fundamentally conservative idea about keeping the courts out of political controversies. Now, when it comes to the question of executive power, there are two questions that have to be asked. The first of which is, does the president have inherent authority given by Article 2 or some other provision of the Constitution to act in the particular way that he, to this date, has been acting? And the executive power is vested in the president by Article 2, and he has the authority to take care that the laws of the sea are faithfully. Second question with respect to executive authority is always, has the president been delegated authority by the statute, by a statute by Congress authority that's not identified in Article 2 as inherent authority of the president. The Affordable Care Act has an extraordinary number of delegations to the president. I counted 162, and I'm sure that or the Secretary of Health and Human Services, and I'm sure that I was not counting all of the ones that are in there. I'm not an expert on the Affordable Care Act. Professor Koppelman is here. He's more of an expert than I am. Some of you are probably more of an expert on the Affordable Care Act. Not a situation, to use the Youngstown reference, in which all of the actions that the president has taken, which Professor Blackman has discussed, have been taken pursuant to his inherent authority without the supplement of delegated authority from Congress. And so to say briefly about the narrow legal question in each of these three categories, I'm going to focus both on the question of delegated authority and inherent authority. As to the individual mandate, I think Professor Blackman and I agree that the president, or that the secretary, that the administration has delegated authority both to define those plans which are going to be grandfathered, and to redefine and to redefine which plans are grandfathered, and to define the hardship exception. That's a very standard administrative law question, and the standard question of whether that definition that's been applied at any particular time is within the scope of the meaning of the statute is something courts deal with all the time. Of course, there have to be cases in which they're standing, and I'll say that more about standing in just a second. So the individual mandate issue seems to me to be an issue of delegated authority. Now, to be sure, there was a congressional action in which the Congress, pursuant to its desire to fix this, was going to fix it in a particular way. But that action doesn't deny the president the authority that he previously had under the previous delegation under the original statute, right? And that's the only question that's relevant to the question of whether there's executive authority. Now, was it politically expedient? Was it politically bad? Was it a feature of something that was necessary because a politician said something about the statute which may or may not have been true? You know, you may not have been old enough to pay attention to what's going on in 2008, but if you're paying attention to 2016, you know, we can't sue politicians because they don't tell the truth, right? So, an employer mandate. Again, this is a question to me, mostly of the question of delegated authority. The definition of how to implement the mandate with respect to employers of different sizes seems to me within the delegation to the secretary to make regulations. And in fact, the delegation in the part of the statute that sets up the employer mandate is an extraordinarily broad, particular kind of delegation. There are some delegations to the executive branch to make rules, to implement particular substantive provisions of the statute, but there are other delegations which essentially delegate to the executive branch not just the authority to implement a substantive, but to define the substance of the obligation, right? That's true in the securities laws, that's true in the finance laws, and a variety of things where Congress says, such and such will happen as defined by the administration of the rulemaking process. And that is how the delegations are written after the statute that has to deal with the employer mandate. Now, it is true that the president delayed the implementation of the employer mandate and other provisions of the statute. And the question there is, does this map strongly enough onto the idea that the president has the constitutional authority to decide not to enforce the law? And to be sure, there's rhetoric, and you describe this in your book, in which the president says, well, really what we're doing here is we're not enforcing the law, it's not really suspending the law. And to be sure, courts have struggled with this from time to time, including the Supreme Court in a series of cases in which it says the president's or the executive branch's decision not to enforce a substantive statute is committed to the president's discretion. We don't judicially review that because that's a power, now an inherent power, of the president under his authority to take care that the law be faithfully executed. Now, is it unconstitutional in some sense that it's not judicially reviewable for the president not to faithfully execute the law? Sure, maybe, but the question here is, so what? Congress is not powerless in situations in which the president doesn't act. Congress has the power of the purse, Congress can supervise appointments, Congress can create private rights of actions in individuals in circumstances in which it wants to create rights which are not dependent upon the executive branch for implementation, right? This is a normal, it's not a normal, it's an extraordinary, but nevertheless
unprecedented.
Unrivaled and unraveled.
Or unrequited, maybe.
It's a very big political question, but it's nevertheless not terribly unique. We have plenty of instances in which the president has decided not to take an enforcement action that on the whole Congress may or may not have wanted him to act. Now, would this Congress have passed a statute to force the president to do something? No, because this Congress actually didn't want the implementation to come into force. As to the contraceptive mandate, here I only want to make the observation that there is no such thing as a non-delegation doctrine in modern constitutional law. Okay? There simply is not. There simply is no limit to Congress's ability to delegate powers to the administrative branch, save something as unusual as the facts of the old-fashioned. That may not be the constitutional law that one prefers, but it is the constitutional law, as I am continually reminding certain of our colleagues on the faculty. And so when the Congress delegates to the president the authority to determine what preventive care means, as well as to put in place implementing regulations, does it create a whole bunch of sensitive issues? Does it create a whole bunch of judgments that maybe the Secretary of Health and Human Services doesn't have any particular expertise in? Now, the Secretary of Health and Human Services is not telling the Little Sisters of the Poor who they can and can't deal with. They're looking at facts on the ground and making a judgment with respect to facts on the ground. But there is no non-delegation doctrine, and there is delegated authority. Now, the last point, I promised to say something about standing, but what I want to say about standing is what I've already said, which is first, seems to me that there's an argument for the conservative doctrine of standing in a particular case that comes from particular political circumstances that Professor Blackburn has referred to, and the second of which is Congress is not powerless, right? If this is a fight between Congress and the president, Congress is not powerless, except to the extent that Congress has been rendered powerless by gridlock, and in those circumstances, yes, the president has declared his authority to act. The question that you have to ask as an administrative lawyer, of power, or is there an inherent power? And everything else about whether the president tells the truth or is an idiot or is making the statute worse than it would otherwise be doesn't really have anything to do with the question of the president's authority.
Thank you. Yeah, I was just Q&A. Much more comfortable than those chairs over there.
You need to give her a few minutes for rebuttal.
Oh, yeah.
Yeah, I'm okay. I'll do my best, though, to respond without using the word delegation every sentence. So. Just some questions.
So we'll take the next 10, 15 minutes for questions. Let's see, Russell Kaufman's got
I think prerogative for the Honorable Mr. Kaufman.
Just want to clarify, you said with respect to the contraceptive and the agencies can make decisions outside of their expertise. Since the agency was specifically delegated the job of deciding what counted.
So, okay, let me respond. That was my argument. My argument was not to decide which drugs are covered. I was actually talking about the non-delegation doctrine. The point was they can't decide which religious groups get an exemption, which don't. It's actually a very narrow argument. They can decide under their expertise as health people that this contraceptive is covered and that one's not. That is not my argument. The argument is they cannot say, because we think this group is more religious than that group, we'll give this one exemption, that one not. That is an inherently legislative judgment. Before you get to the non-delegation doctrine, call it Chevron Step 0, whatever you want, major question doctrine, Brown and Williamson, FDA, whatever you want to call it, that is ultra vires, and that they cannot do.
That's not where my question is
Good.
If that's the case, little sisters necessarily lose because the agency would have to say it's just not our job to make any exemptions.
And that violates RFRA.
Everyone loses.
And that violates RFRA. If the answer was no one gets an exemption, that violates RFRA.
So under RFRA, the federal government has an obligation to make an exemption, but the agency that's administering the statute, which is bound by RFRA, is not allowed to follow the statute.
They would have to exempt everyone. They would have to exempt everyone.
Everyone.
RFRA
means that if
anyone who is free exercise substantially burdened, and the government can do so in the least restrictive way.
But doesn't the government have to figure out who that is? And
people would apply for injection. You determine within the agency, is there a substantial burden? The answer is yes, and you give an exemption. That's all the power, that's all the delegated, if I may, power permits them to do. They don't have the power to play God, right? They don't have the power to say, this group gets it, this group doesn't, this group gets a skim milk, this one gets full exemption. That is beyond their ken, and there's not a single iota in the history of the law suggesting they have that power. Not a single doubt.
They do have to decide.
RFRA is a delegation. The delegation comes from RFRA and not the ACA, right? And
they still have to pick and choose against the
exemption, but not accommodation, the difference, right? Let me explain this. The ACA has two different approaches under President Obama's reg. There's an exemption, which means none of your employees get it. Which means your employees get it through your plan, but you're not paying for it. They get an exemption, but not an accommodation. The accommodation is ultra vires. They can't decide who gets this less form burden. If there's a substantial burden under the ACA, all they can do is exempt. This is a moot court, by the way.
Accommodation drafted by the Supreme Court in the Hobby Lobby case?
No, all Hobby Lobbies, you're thinking maybe Wheaton College, but all Hobby Lobby said was for-profit corporations can exercise this, and there's a substantial burden. The Wheaton College case said that this accommodation is a least restricted alternative, but that doesn't answer the threshold question of whether they have the authority to do it in the first place. Now they've argued in amicus brief, otherwise they do not have that authority. It's not delegated.
So I think it is. I mean, I don't think you can read ACA and RFRA together without saying that the administration has to make these decisions. I mean, unless and the administration makes these sorts of decisions all the time under conscientious objector statutes.
But again, objectors are exempted. They're not giving us. It's not like, okay, you can go to war, but you don't have to hold a gun, right? And then that new movie, Hacksaw Ridge, right? You're exempted from service if you're Amish, right? You're exempted from paying tax returns for a certain group. They can exempt these groups, but they can't make this middle-of-the-ground accommodation that simply burdens them less. And the government's conceded that there's a lesser burden. I don't want to belabor this point, but if you want to read the brief by the Cato Institute, in the case of Zubik against Burwell, I make this argument, and also I have a Harvard Law Review coming out in about 4 weeks, so you can read that also. But the brief's probably
Is this 4 articles in the Harvard Law Review or 1 that makes all these arguments?
There's one more.
Okay. Got it.
So I've got a question shifting gears a little bit for Professor Blackman about standing. Can you explain at the rub of the continued unenforcement of the individual and employer mandates that plaintiffs don't stand to sue? So if there's no standing to sue, and if there isn't another enforcement mechanism, make sure that the president enforces the law, does the Supreme Court need to tinker with its standing?
So I think whatever agree, I'm not a fan of our standing jurisprudence. I'm really not. I think the injury requirement is perhaps too strong. As far as creating private cause of action, the spoke, I don't think that would work. Congress said, we will create a private cause of action so you can sue Obamacare delays. We can argue that we'll use that later. I think under the Article 3 standing injury requirement, they can. I think this is problematic because there's some actions that I think are clearly unconstitutional, really illegal. Nick Bagley teaches at Enrollment Mater. Michigan has been a strong ACA supporter. Claims that lobbies delays are simply contrary to statute, that there's not an adequate delegation. But because no one's injured, these so-called benevolent suspensions, you never get this to the court. And this is why I can argue my book, whether it's legal or not, but I can't make this argument in Article 3.
Additional questions?
Come on, you just came for the sandwiches? Yes, sir, in the front.
A question for Professor Speta. Maybe this is a question about what ought to be required, but with regard to the contraceptive mandate that sprung from the Medicare screenings part of it, I mean, don't you worry that just because of how vague preventive care screening is, I think if you just ask a random person on the street, they would have a pretty clear idea of what preventive screenings were, mammograms, et cetera. Don't you worry that because of that kind of broad discretion that agencies have, Congress could then kind of hide an elephant in the that
Mouthful.
yeah, exactly. What did I say?
Anthill.
Yeah. Just that very disarming language then creates, pretty wide deference to agencies, create this fight that should be within the political branches, right?
Sure, but that is an issue. I mean, it's an issue that's been much discussed in administrative law and in legislation. We know that sometimes broad delegations to administrative agencies are made on a view of delegation of expertise, right? This is a really hard question. We think that and we do want to have extraordinarily broad powers, but sometimes delegations to agencies are made in political compromises where the Congress decides we're not going to address what the substance of this is, and we're going to punt. And we're going to punt because we're going to save our own skins from election consequences. With respect to that, the resolution that we've reached on those questions, though, is to ask whether there's been the delegation or not. Now, I'm a particular fan of a doctrine called the delegation doctrine, which is to say, look at the statute and make sure that there's actually been a broad delegation. If there's actually been a broad delegation, okay. And so there are cases, and I'm not sure whether I buy Brown and Williamson as a good example of this, but Gonzalez versus Oregon, in which you say, you look at the statute and you say, no, okay, that's not really a delegation of authority to do that, to do a particular thing. In the case of Gonzalez versus Oregon, it was to shut down physician-assisted suicide through using the Attorney General's authority to license physicians to prescribe drugs. Okay, so yes, it creates a variety of political problems. I think the answer that I would apply, and the answer that I think the structure of the Constitution applies, if you don't like what Congress is doing, you vote, right? And the fact that Congress has turned around for whatever reason, good, bad, or ugly, to delegate an enormous amount of power to the administrative agency just isn't the question. The question is whether the power is delegated.
So your question is very astute. If you look at the legislative history of this provision, they were only talking about mammograms. All they were talking about is mammograms, breast cancer, mammograms, colonoscopy, all they were talking about is mammograms. But if you look at the legislative history very carefully, in 4 references, they mention family planning. Not birth control, not contraceptive, family planning. That is a close to getting a record. They were indeed punting, trying to save their skins. That's precisely what they're doing. They realized if they made a thing saying you have to require employers to pay for the morning after pill, the EC would have been dead. Bob Casey in Pennsylvania, Joe Manchin, they never voted for it. They couldn't, okay? So the first part of your question was actually very astute. The second part is about Justice Scalia's admonition that Congress does not hide elephants in mouse holes. I fear that now Nino is no longer with us, that doctrine may go by the wayside. Although I'm a fan of this doctrine, I would look to see, had Congress actually considered the question before this, right? Was there any discussion that Congress wanted these agencies to play decisions on faith and morality? And the answer is no. There's nothing in the record. There's nothing in the delegation. I don't care how big of a magnifying glass you use. There's nothing in there that gets to that answer. Also, Oregon is a case to look at, right? There's nothing here saying, okay, you could decide which drugs to cover, but you can't play this and that with reaching. Professor Kaufman?
No, just, I mean, there are hard questions of delegation. There are hard questions of delegation. I just don't see how the preventive care problem is a problem of hard delegation any more than Congress doesn't have to pass a new statute when a soldier is wounded on the battlefield and medic decides, without an act of Congress telling him to look after this wounded soldier, that he's going to look after this person. The basic reason for the preventive care requirement is that there was a prisoner's dilemma among the insurance companies. This year, the insurance company, mammogram or your colonoscopy or your validation, whatever, for preventive care, I might not get gains from it because you might have a different insurance policy. And so the reason for the preventive care mandate was all of these types of treatment are treatments that collectively it saves more money to provide them for people than not to provide them for people. So it's even good for the insurance companies if you're required to do them, if everybody else is required to do them too. If the medical treatment is going to prevent more expensive treatment later. Well, contraception is like that. It's cheaper to pay for contraception than to pay for pregnancy. And a huge number of pregnancies are unintended. Unintended pregnancies are another bad consequence of not providing preventive care early on. There are big delegations, but this just isn't one of them.
So this is why I described the major question doctrine, which has been dubbed the Chevron Step Zero inquiry. The court has said certain questions of major political, social, economic significance, the Congress doesn't address remotely. The entire thing about which drugs to cover, I'm with you, they can do that. Under Chevron, they can make the determination. But the aspect of giving some groups an accommodation, some exemption, that is not something that they were given the power to do.
It seems to be oscillating back and forth between the question of unconstitutional delegation.
I've never said that. No, I've never said that. I did not mention the non-delegation doctrine once. So there's Chevron Step Zero question. Now, is Chevron Step Zero a major question a species of non-delegation? But I've not used the word non-delegation. Not a word I use. Student questions, maybe. As much as I love faculty dialogue. Yes, sir.
Why do you think the president was opposed to letting Congress adjust the law in 2013?
The reason why is because if the bill was opened up, they probably made other changes the president didn't like, and he'd be in a position where he couldn't veto it.
And hasn't that been done?
ACA?
No, just in general.
Yeah. Usually when you want to make a change, you have to take whatever comes with it. And the president's put in a tough spot. So he used executive action to obviate the difficult political choice of vetoing this, like that. Right? That's exactly why this happened. There have been changes to the ACA made on a bipartisan basis. One I'll mention today was the Cadillac tax. This was actually one of the few things that the ACA actually liked. It said if you have a very generous plan, it puts a 40% excise tax. We have a system where health insurance is not taxed. That is an awful idea. We should not be compensating people through their health insurance. We should give people cash they can use to invest. This 40% excise tax has actually got people off that plan and onto a higher compensation for their own pocket. This is unpopular with labor unions because they get their most form of compensation through their benefits. So of course, let's delay the Cadillac tax. It'll never go into effect. This was a mistake. This should have gone into effect. It would have actually helped the healthcare market, but it will never go into effect. Indeed, one of the WikiLeaks emails I read this morning from Hillary Clinton said, let's support this plan to unravel the ACA, right? Because if we let people save these expensive plans, no cost control, this thing will come crumbling down like a house of cards. Go check HRD 27 at Hillary Clinton emails, whatever it's .com. Emails are in there.
Yeah, we agree that one of the reasons that the administration didn't want the Congress to deal with these was the fear of amendments that would unravel.
There you go.
We could probably disagree on where that fear comes from and the history behind the gridlock, et cetera. But yeah, it's a political matter.
Maybe one or two more questions. Yes, to that.
It's going to be around 4 years.
So in name, yes. In substance, I don't know. So I'll simply assume that Clinton wins the White House. At this point, that's the most likely scenario. She's in trouble. Okay, it's not doing particularly well. And in many places, the governor of Minnesota said, for example, healthcare is unaffordable. The ACA has not been good enough at drawing people in. It's not been good about lowering costs. So actually, this year, enrollment in the markets will be flat or actually down, if you look at the projections. This isn't sustainable. So what are some proposals? Well, we can increase the subsidies to make it more affordable. Okay? That balloons the deficit, but it doesn't do anything to control the fact that even if your premium goes down, your deductibles are still high. The insurance companies are simply exiting the markets. Professor Kaufman will probably chime in here, is to get to the point where you have a movement for a public option. Okay, what's a public option? It's a plan that competes with the private insurers. Once you have a government plan that's in no way pegged to the money coming in, the private insurers will exit this individual market, and will basically destroy the individual market like 4 or 5 years flat. It's pretty impressive if you think about it. Will the public option be here? It depends. The Democrats have 60 votes in the Senate, or maybe they'll get rid of the filibuster altogether and just be done with this entire business. If the filibuster is eliminated, I think that'll be the first bill brought to Hillary's desk, in which case the ACA will exist in name only, but the initial calculus, how to make markets work and this and that will not have survived 4 years. Thank you for the good question. One more question?
We've got time for one more, if anyone has one more question. All right, well, what we got? All right,
save on the bell. My last one.
I was just curious to hear what your, like a broad strokes version of your rebuttal into Professor Speta's broad delegation theory.
I mean, look, read the statute, right? So an individual mandate portion, right? The HHS can set the level of minimum essential coverage. They can say, okay, you know what? Let's downgrade the required coverage to these very expensive plans. They didn't do that. Instead, they said, we're not going to enforce on regs. So they could have downgraded it through rulemaking, but they're simply not going to enforce it. With the employer mandate, it became very clear that the reason why they're doing this was not transitional implementation. They're doing this because it was unpopular, right? There was no actual legal reason to delay it the way they did and say these people get it, these people don't. With respect to the contraceptive mandate, I don't think this is a non-delegation doctrine issue. I think this is a major question doctrine issue under Brian Williamson and Charles Oregon and UARG and a couple other recent cases, T.V. Burwell and others, where agencies that lack competency cannot make these major decisions of law. How's that?
So, yeah, let me be clear. I'm not saying that the president had delegated or the secretary had delegated authority to say, I'm waiving the date of the effective date of the statute, right? That raises the question, though, of what happens when the administration or the executive branch decides, I'm not going to enforce a law for ever, or now, etc. I will concede that that is a somewhat difficult question. It's difficult to say, even if I'm right, which I think I am, that it's not judicially reviewable, it's difficult to say that the president is or isn't acting constitutionally. The argument that he or she is acting constitutionally is that that's their decision about whether and to what extent to enforce the law. And if Congress doesn't like that, Congress can resort in different ways to remedying that. But this is an open question. The Fifth Circuit case in U.S. versus Texas, where this sort of arises in the immigration context, is, in my view, a travesty of administrative law because it was a non-enforcement decision which the Fifth Circuit simply said was a substantive rulemaking and therefore was invalid. If that was its view, it should have said it was a substantive rulemaking that didn't go through notice and comment and stopped there. It didn't. Right, treated it as a substantive rule and then evaluated whether it was. But you know, on the other side is the Massachusetts versus EPA case about farming regulation. You know, at some point, our normal political expectation is that the president would take the substantive statute and the deadlines that are in the statute and implement them. Right, that's the normal. But this isn't normal politics.
And if you want to read USP Texas, know where you can read about it.
In your new Harvard Law Review.
Exactly. Thank you all so much. Have a wonderful day.
I wasn't aware of that until a couple of days ago, and so see if you even recall.
No.